back to our origin of We the People. Tackling current issues, both political and legal, with common sense. As We the People, we must bring common sense back to make our lives better. Only on Now Media TV.
Hello and good evening. Welcome back to another episode of We the People. I am your hostess, Alina Gonzalez Dockery, and I am excited that I am joined by attorney Thomas Erb Jr., founder of Erb Legal LLC in Ohio. Thomas has been recognized for his efficiency, compassion, and ability to protect his clients' interests. And he is a superbly talented family law lawyer who is known for his relentless advocacy, courtroom strength, and strategic negotiations. With a wide-ranging legal experience in everything from criminal defense to civil litigation and appellate matters, kudos to you for the appellate matters, Tom has honed his skills in domestic law and never turned back. And I can tell you, as a family law attorney of almost 30 years, that is a honing by knives and spears. Focusing on family law guiding his clients through some of the most difficult times of their lives with clarity and confidence. Tom has been recognized with a Martindale-Hubbell AV preeminent rating as one of the top superstar attorneys and elite lawyers for divorce and family law. And cheering on the Buckeyes on his off chance, and as you can see in his background, an avid golfer. Tom, welcome to the show.
Thank you. It's great to be here. That was quite an introduction.
I was playing around in your website, and I get excited when I get to speak to attorneys who are in a field that I am in, but I'd like to see the differences between like Ohio and Florida. But also I do get excited to see somebody who is so well recognized, who has done things like, look, you were awarded with the Client Champion in 2021, and that's based on your clients' reviews and how they see you. And that is an amazing feat, especially in family law, where the emotional pitfalls and roller coasters that our clients go through can easily be turned on to an attorney. So if I can toot your horn, I will toot it loudly. So anyway, welcome, Tom.
Thank you.
So Tom, I mean, I know there's definitely some differences, and there's certain things that are going on in Ohio. I have been seeing a lot more, and I've been, advising clients even of younger years, as some will say, of the necessity of looking at or assessing whether they need a prenuptial agreement. I mean, is this something that you do a lot in your firm?
It comes up quite a bit. I always tell everybody you ought to have a prenuptial agreement. Then there's no dispute as to whether you have separate property or not later on, and what's going to happen with that property. Unfortunately, far too often, it's kind of the last thing that people think about. In fact, we just got a call a couple days ago. Somebody was 15 days away from their wedding date and wanted to start negotiating a prenuptial agreement. And I was like, yeah, okay, we'll do this. Here's the pitfalls of trying to do this 15 days before a wedding.
Well, and then was this to create, or was there already a proposed agreement?
No, this was to create one. So nothing like being under the gun.
Well, and then there's always the question of, is there undue duress and everything? Because if it's if marriage is predicated on whether you would, have this written up, then yeah, there might be a problem, I could imagine. Which then kind of goes into, after marriage, there can be a postnuptial agreement as well, which people don't think about often. But I want to, before I jump into postnuptials, let's talk about some of the prenuptial, for people who don't understand what a prenuptial agreement is and how it pertains to, especially in Ohio, which is where you're based. Give us an overview of let's just say if I were a new client or a prospective client looking for an agreement?
Well, so the first thing you have to know about prenuptial agreements is there has to be a full disclosure of all of your assets and debts. Um, if you don't get past that hurdle, then none of the other provisions really come into play. And in fact, that's probably one of the most invalidated portions of an agreement if you want your prenup to survive, um, you know, in the event that you get divorced. And that's really what a prenup is for. How are we going to divide our assets and debts in the event that we get a divorce in the future? And I think a lot of people don't want to think about, I'm going to get divorced or even think in that direction. But unfortunately, the realities are, as people get older and get married older, you've already acquired, stuff in your life, and it's what are we going to do with that and how we're going to divide it. So the first thing you have to have full disclosure, like completely full disclosure. It also has to be signed by both the parties. It has to be in writing. It's always best if both parties are represented by independent counsel. Yes, that raises the cost a little bit, but if somebody's not represented, it might be questioned down the road. So a prenuptial agreement can basically take care of all the financial aspects of your life. However, children issues are, at least in Ohio, never allowed in prenuptial agreements, either the custody or the visitation or child support. You can't cover any of that in a prenuptial agreement. That's all always under the jurisdiction of the court in the event that you already get divorced.
And the same here. You can't waive child support. You can waive alimony, and I think some people will think, oh, I'm signing my life away. If I get a divorce, I don't have anything. Not necessarily. If you have a good attorney like Tom, you can negotiate the terms of in the event of a divorce, and this is what will be provided and things like that. It's not a all or nothing type of situation. Although,
Well, Ohio's a court of equity, and so a lot of times I advise my clients, especially if I'm representing the person that may have to pay spousal support, that you don't want to say zero.
mhm.
Because especially for a long-term marriage, if you say my spouse will never get spousal support under any circumstances, the court could invalidate it just based on the fact that that's just not equitable. So usually you want to build in, some sort of stepping stones or ramps up, or after so many years I'm going to give them this amount of money as a gross amount. There's all sorts of ways you can play with it. There's all sorts of ways to negotiate around that. But if you do zero, a court's going to take a really, I'm not saying you can't win on it, but I think the court's going to take a much harder and harsher look at it than they would if there was something reasonable in there.
Oh, and I totally concur. I mean, if you have a marriage that is 35, 37 years, of course, going to look at that going, no, you've amassed all these riches and stuff. But also, let's say, and I don't know how maybe how common it is in your neck of the woods, but down here we have like very well established, financially established men who may be marrying younger women. Um, so for that, for those younger women, you want to have an attorney that is astute and being able to negotiate what will be the circumstances in the event of a divorce. But also, at least here in Florida, I negotiate also what happens after death. I mean, yes, the wills is a separate entity, but a separate mechanism, or wills and trust. But there are times where I put securities within the prenuptial agreement to ensure, like, say, a life estate interest in a home or certain safety nets, if you will. Is this something that you also have found in your practice?
We don't do that as much here. Typically there are some sort of death provisions in there, but they're not as extensive as what you're talking about. But really anything's negotiable, and you really have to think about any eventuality that's going to happen, in the marriage of those two people.
So, well, and it's, as I was telling you off camera, I'm loving the fact that I have what I call the golden marriages, that these couples are coming there later in years, they're widowed or widowers or divorced and they're getting remarried. And this is why we have been, maybe that's why we have a little bit more of what should happen if a, you know, just to secure one spouse that the other should be deceased. You know, I am curious because I have been talking with like 20 some year olds, 30 some year olds that are getting married or actually getting divorced, the importance of a prenuptial. What are your age ranges that you're finding as a norm for your prenuptial agreement clients?
I would say most of them are probably in their 30s. And I think that's because once you reach 30, you've started to acquire assets that you're now worried about, or you started, a landscaping business or some other sort of business, and you want to make sure that your landscaping business is protected in the event that you get divorced. I'd say primarily 30s. Obviously we do have people in their 20s, 40s, 50s. I haven't any over that at this juncture in my career, but you just never know.
Well, and I think it might be because most of the people that are retiree are from up north and stuff. I'm in a very heavily retired area, let's put it that way, here in Southwest Florida. But I do love the fact that you do deal with the 30-year-olds, because especially with, I shouldn't say kids, but with these younger adults, they're obtaining more assets, investments, and things like that should be secure. And I think it's so important for these young couples to come into a marriage with open eyes as to everything, and it is honesty. We're going to take a quick commercial break. We're going to come right back to Tom, and I have some questions about what happens after marriage as years progress. So tune right back. Thank you. How to make contracts sound enjoyable.